Hello friends, in the series on the income tax cases, today we will discuss a very important issue that whether section 147 read with section 148 proceedings can be initiated against the assessee solely on the basis of information which has come to the assessing officer in the form of audit objection. Second thing, if the information is received by the assessing officer in the form of audit objection, so whether solely on this basis or in this case also, the formation of belief that income has escaped assessment is an essential condition to issue the notice under section 148. This interesting issue has come before the Honorable Gujarat High Court in the form of a writ petition in the case of Adani Power, Assistant Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 720. The date of the judgment is 1st May 2023. The facts of the case are very interesting. In the present case, the assessment year is assessment year 16-17 and an audit objection has been received by the assessing officer that the assessee has claimed CSR expenses which the assessee is not entitled to claim that expenses, and on the basis of that audit objection, without formation of the belief that whether the income has escaped assessment or not, just on the sole basis of audit objection, the assessing officer issued the notice to the assessee under section 148. In this case, there are same facts for the assessment year 17-18 when the audit objection were received by the assessing officer from the Joint Commissioner audit for the assessment year 17-18 on the same issue of CSR expenses, and for the assessment year 17-18 the learned assessing officer was of the opinion that the assessment has been done in a proper manner and the assessee is entitled to claim the CSR expenses, and the notice under section 148 was not held valid in that case. But on the same issue for the assessment year 16-17, that is on the CSR expenses in the form of audit objection, the assessing officer has issued the notice to the assessee under section 148. The assessee filed a writ petition for this notice on the pretext that formation of belief that income has escaped assessment has not been made by the assessing officer, and there is no independent application of mind by the assessing officer in issuing the notice under section 148. When the Gujarat High Court heard this matter, the Gujarat High Court said that there is no doubt that an audit objection may serve as information that income has escaped assessment, but at the same time formation of belief on the part of the assessing officer that income has escaped assessment is equally important. The court said that for the assessment year 17-18, assessing officer has not agreed with the audit objection raised by the Joint Commissioner audit on the basis of CSR expenses for the assessment year 17-18. The court said that recording of the reasons for the same issue for the assessment year 16-17 is not independent application of mind. Friends, accordingly, the Gujarat High Court quashed the notice under section 148. But the takeaway from this case is that in this case, the client is a high profile client, that is Adani Power Maharashtra Limited. So the client can afford in challenging, in contesting the notices which are issued without application of mind. But whether a normal assessee can afford in going to the writ petitions, the question is certainly no, and due to which the assessee has to suffer, because nowadays whatever the notices are being issued in the form of section 148 just on the basis of the information from the inside portal, without application of mind. So in these type of circumstances, the quality of the assessment is being deteriorated, because when the notice is issued under section 148A clause B, whatever the responses the assessee is submitting to the department, they are not being considered in the true sense, and they are culminating into section 148 notices and ultimately into the additions. The same order which is done in section 148A clause D is being copy pasted in the draft assessment orders and in the assessment orders. So as on date, the fate of the assessments, the quality of the assessments is very bad, and the assessee is also not getting the relief from the CIT appeals, because the CIT appeals are pending since more than 3 to 4 years. Whatever the orders are coming from the CIT appeals, only those orders are coming which are ex parte appellate orders by the Commissioner of Income Tax. Wherever we have submitted some submissions which are running into some 40-50 pages, they are not considering those submissions. The orders are not coming. They are not giving the VC, virtual hearing, in those cases, and those cases have been kept in a bucket which is not being opened by the appellate authorities. So this is a very bad situation as far as the litigation of the income tax is concerned. In the nutshell, in this case, the Gujarat High Court quashed the assessment proceedings in the form of section 148 notice. At the end of this video, once again I am repeating the name of the case. The name of the case is Adani Power Maharashtra Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 720. The matter has been decided by Gujarat High Court, and the date of the judgment is 1st May 2023. Thank you, friends.